Here they are. Number one, to what extent, if any, should officer discretion to conduct motor vehicle searches be subject to supervisory control? So do you vest the discretion to conduct these searches solely in the officer who's on the scene without any further involvement of command and control authorities, supervisory personnel, sergeant, or whatever, or is there some communication or supervision that's necessary before conducting the search? If the search is to be undertaken, what lawful basis will support it? In other words, is this going to be something that's going to be done through one of the exceptions to the warrant requirement, or is it going to be done by consent? Is it going to be something where there's going to be a search warrant sought? What exception to the warrant requirement is going to be used? What's going to support this search? Next, what are the factors militating in favor of using an exception to the warrant requirement in a given case? Contrast that with what are the factors militating in favor of seeking a telephonic search warrant, and who should make the decision? I want you to kind of think about something when you're dealing with these particular issues, that if you're going to rely upon an exception to the warrant requirement in conducting a search, being mindful of the fact that you never know what you're going to find when you start searching. Even the most innocent-looking search initially may yield some very significant evidence of criminal activity. The issue becomes that if you're going to rely on an exception to the warrant requirement, the statistical likelihood of you having a motion suppress filed against you at some point that you're going to have to deal with is pretty high. And also high is the likelihood of some adverse determination being made on your motion to suppress. Contrast that with utilizing a search warrant where the likelihood of you getting a motion to suppress is dramatically reduced. And in those situations where there is a motion to suppress filed, the likelihood of you prevailing is also enhanced due to some procedural components associated with that. So these are the types of analysis you're going to go through when you're doing this kind of making these decisions from a policy standpoint. If you're going to have this choice, who's the one who's going to make the determination, whether it's going to be senior personnel, sergeant, or patrol officer on the street? What level of resources in terms of time and manpower should be allocated for the purpose of conducting the search? This is especially important if you like Clinton Township, for example, where you have a pretty small department. Things can start hopping real fast. You get a domestic violence call in one end of town, and then Rep 31, you've got a drunk driving stop. You know, you've got time and personnel allocation issues. And this is one for you, Billy. Should video and audio recording become routine component of vehicle searches? Now, again, there's no answers to these at this point. We really want to go through the materials today before we go back and revisit these. Bill had an additional one we talked about this morning, which I think is probably the most important one of all, and I never even thought about it.
And that is, as we talk about these cases today and the methods of searching and what problems the department is going to have to face, when we talk about discretion and who's going to exercise the discretion, you have to understand that the more there's going to be discretion in regard to these automobile searches, the more potentiality there may be for racial profiling issues that may not only affect the state police that we know have been involved in these problems in the past, but now the specter may be that these problems may have to deal with municipalities in the way municipal police deal with situations. For instance, if you have a situation where you have police officers having the discretion to make the decision as to whether you get a telephonic search warrant or you deal with the matter in a different way, including deciding that searching the car is not worth it and letting the people just leave without any further action being taken. If you think about that for a minute, there may be good reasons in particular cases for deciding not to spend the 45 minutes that's going to be necessary in order to get a telephonic search warrant and make that work. But the problem is, if your department decides, not as a matter of policy, but as a matter of practice, that it's the white teenagers who get sent on their way all the time, and it's the blacks and Hispanics who end up with searches being made, you're going to be setting yourselves up for a potential lawsuit down the line, and who knows what in terms of supervision by the federal government, et cetera, et cetera. So these are some of the issues that we want you to keep in mind as we start talking about the cases, and then we'll come back to these at the end. There are three historical cases that we didn't put in your materials that you will probably remember from either your police training days or from your law school days. And the first of these cases is Carroll versus the United States, a 1925 Supreme Court case. The case was simple enough. The police had probable cause to believe that the Carroll boys were bootleggers and were transporting liquor illegally between cities A and B. Police are on routine patrol one day and they see the Carroll boys driving a vehicle between A and B, and so they pull them over. They have plenty of probable cause to search the vehicle, but they have no warrant. What they also don't have is any probable cause to arrest the Carroll boys, because until the booze is found, they have nothing to arrest the Carroll boys on. So you have a car stop, probable cause to search the car, but no probable cause yet to arrest the occupants of the vehicle. And the question went to the Supreme Court as to whether or not the police were allowed to search the Carroll boys' car without the nicety of obtaining a warrant. And the court said yes. And with that decision, the automobile exception was born. The court said, we have to recognize that there are going to be some circumstances, particularly involving vehicles, where the police will have a situation like this, where they have probable cause to search the vehicle, but no mechanism for actually taking the vehicle into custody because they don't have the people under arrest. And that being the case, if the police leave for the purpose of going and getting a warrant, what's going to happen to the car? It's going to disappear because the police have no basis for holding the Carroll boys in custody until the car is searched and something is found. They can just drive the car away. So the court said we have to do something to allow the police to be able to conduct a search under those kinds of circumstances without a warrant, and so they created the automobile exception. The automobile exception, as originally stated, was you needed probable cause and you needed some kind of exigent circumstance that prevented the police from being able to get a warrant. And in this particular case, in the Carroll case, the exigent circumstance was the mobility of the vehicle, the ability of the Carroll boys to drive that vehicle away. So we have this auto exception established in 1925. Let's jump ahead to 1970. In 1970, the Supreme Court decided another case. Again, Supreme Court of the United States decided a case called Chambers versus Maroney. Chambers versus Maroney dealt with a slightly different situation. Car was stopped out on the road, and the police had probable cause to believe that the occupants of this vehicle were involved in an armed robbery. They arrest the occupants of the vehicle. So now, unlike the Carroll situation, here the people who are in the vehicle have been arrested so that they no longer pose any threat to the mobility of the vehicle. The police also now have probable cause, believing that this vehicle has been involved in an armed robbery, or the people inside it have, to search the car. But the police don't search the car at the scene. Instead, what they do is they transport the car back to their headquarters and then search it there, again, without the nicety of getting a warrant. And the question that the Supreme Court had to decide in that situation is whether that activity on the part of the police was justifiable. And the court said yes. And the rationale was this. The court said, look, here's a situation where the police clearly could have used the automobile exception at the scene. They had probable cause to believe that this vehicle, which was mobile, may have contained items of evidence, and they could have searched it right there. They didn't do that. What they did, though, said the court, was equally good. They seized the vehicle, took it to headquarters, and then searched it later. The Supreme Court said, from a constitutional perspective, there is no difference between a search and a seizure. From a constitutional perspective, they are both equivalent actions. Therefore, there was nothing wrong with the police taking the vehicle from the scene and moving it back to headquarters and then searching it there without a warrant. The last case we want to talk about in regard to background was in 1996. It was a case called Pennsylvania versus Lebron. The police had probable cause to search the vehicle at the scene. The problem was that there was absolutely no reason why the police could not have gotten a search warrant. The car was involved in a drug investigation. It was parked. There was nobody there to drive it away. The police, in effect, had control over the vehicle at the scene. So there was no particular threat. There was no reason why the police couldn't have gone and gotten a warrant and come back and searched the car. And the case that goes up to the Supreme Court is, in that situation, does the automobile exception apply, or should the police get a warrant in that situation? And the Supreme Court of the United States basically surrenders at that point and says there's no reason why the auto exception shouldn't apply. And the court says, we've talked in the past, as far back as Carroll, that the automobile exception relies on the fact that there are some exigent circumstances that prevent the police from getting a warrant. And mobility, of course, was the one that the court, first noted in Carroll. What the court does now is basically to say, look, if you're talking about a vehicle and the vehicle is potentially mobile, that is the exigency in and of itself. You don't need anything else. So on the federal level, the automobile exception has become very simple. If you got a car and you got probable cause for it, the auto exception applies. Very simple, easy rule. Here's the problem. The New Jersey Supreme Court has gone a completely different direction from federal law in this regard. And Bob is going to start to take you through the development of the New Jersey law in this regard.
That's really why we're here today. And it's important that everyone understand that from the perspective of all of us in the room here, under our system of federalism, individual states are perfectly fine in the sense of interpreting their own state constitutions to provide more protection under the state constitution than you were entitled to under the United States Constitution. So you have to think about the United States Constitution as being a floor as opposed to a ceiling. And by that I mean you regard the United States Constitution, the Bill of Rights, the Sixth of the Fourth Amendment in particular, as the minimum level of protection you're entitled to in the United States. Individual states can give you more protection. And that's been our history in New Jersey much more frequently these days, starting off approximately in 1964 when our Supreme Court started giving enhanced protections under the state constitutional equivalent to the Fourth Amendment, which for our purposes is Article 1, Paragraph 7 of our state constitution of 1947.